All right. Patent exhaustion and one, oops, let me share first. Patent exhaustion and one-time use restrictions. What the heck does that mean? The premise of the doctrine of patent exhaustion is that the first sale by a patentee of an article embodying his invention exhausts his patent rights in the article. So maybe I buy this really awesome patented ergonomic chair. It's got this wonderful lumbar support and this tushy cushion that just fits me perfectly, and I love the chair. And I use it for a while, and then I change to a new office. It doesn't fit with the new desk really well, so I sell it. Well, the person or company that sold me that patented chair lost all patent rights in that chair. I can turn around and sell it, and nobody can tell me I can't. I can turn it into a doghouse. I can do whatever I want with it. There's all kinds of patents in my cell phone. I could say, wow, I want to use it as a frisbee, and nobody can tell me I can't. I don't want to. I like my phone. But once you sell an item, you no longer have any rights as a patent holder. You no longer have rights in that item. Now, there are a little bit of ways around that, a little bit of wiggle room in post-sale restrictions in terms of bag tags and things like that. But for the most part, once you sell it, I can do what I want with it in this item. The trick is with seed, I'm going to plant that seed and grow more seed. So imagine this. I take a handful of seed and I grow more seed. What was I sold? The original handful of seed, not the seed that I grew. This was never sold. I don't own the rights to that. I made a copy. That would be like me saying, well, you sold me this phone, you have no more rights in it or rights to it. That's true. But I can't copy this phone and then resell it. And with living things, that's what you're effectively doing. You're taking one, you're making a copy of it, and then selling the copy. So let's go through that again. The premise of the doctrine of patent exhaustion is that the first sale by a patentee, when you sell that item, that article that embodies your invention, whatever it is, it's some fancy chair that's patented, some seed that's patented, whatever, is it exhausts his patent rights in that article. You no longer have patent rights in that specific article. While the doctrine might appear to benefit an accused infringer, somebody who stole seed, whatever, the Federal Circuit and the district courts have held that the restrictions in licensing agreements against using patented seeds or plants to produce additional seeds for planting do not violate the patent exhaustion and first sale doctrines. Because you never sold me those seeds. So when I turn around and sell them to somebody else, I'm selling a copy. So very desperate attempts by people to say, no. This patent exhaustion is our defense. And courts have consistently held for decades, no, no, not at all. Monsanto versus McFarling. The Federal Circuit Court held that Monsanto's licensing agreement prohibiting saving seeds did not violate the doctrines of patent exhaustion and first sale because the restriction in the agreement were within the scope of Monsanto's patent rights. Monsanto had every right to restrict the use of reselling seed or saving and replanting seed from grown from the seed that was originally purchased. The court reasoned that the first sale doctrine of exhaustion of patent rights is not implicated, as the new seed grown from the original batch had never been sold, and that the original sale of the seed did not confer a license to construct new seeds. And again, that's where you can clarify. You have the right to use our seed that you bought to grow new seeds, but those seeds have to be used for grain or storage purposes, not replanting. Or grain or forage. Did I say storage? Whatever. Grain or forage. You either feed animals, or you make bread, or you make cooking oil. Whatever you're going to do with that seed, you do it. You know, normal use, not save and replant. And between the utility patents and the Plant Variety Protection Act, or plant patent, along with bag tags to really clear it up, they're a pretty strong set of tools these days, especially now that we have DNA fingerprinting that also can be used to basically show, hey, what they're growing is ours. Monsanto versus Scruggs, the court held that Monsanto's single-use restriction was valid because it falls within the patent grant, relates to subject matter within the scope of patent claims. Again, another example of the same thing. The court found that Monsanto never made an unrestricted sale of its seeds technology. Since Monsanto never made an unrestricted sale of its technology, the court ruled the doctrine of first sale patent exhaustion afford no protection to the defendants. And that's a new concept here. You never sold it without restrictions. And that's where companies have gotten really good. If I'm a plant breeder and I grow up a new variety of seed, and I sell that seed before I have filed for a patent, before I filed for a patent, or a PVP, or both, that's it. I sold it once. I'm never going to get the patent if anybody ever finds out that I sold that seed. You can't do that. And if it can be shown that I sold the seed prior to having any protection, I can no longer get protection. The seed's already, quote, out in the wild, and there's no way I can then pull that back and say, I want to restrict it afterwards with these PVPs or utility patents. And so what do companies do? They file right away. You file your utility patent and your PVP or your plant patent right away before you sell anything. Now, there are some loopholes in there. You can do some research, but you can't sell it. You've got to do trials. You've got to make sure it's growing. You got to run some tests, but you can't sell the seed, period. Once you're confident with your trials, then you file your patent. If it doesn't pan out, withdraw the patent. If it does pan out as a good variety, push forward, get that patent. But you don't ever want to sell anything, not even to a friend. If a nickel changes hands during that transaction and you exchanged that nickel prior to the date, the official date, which is the start of your application for patent protection, you're lost. You're going to lose a court case if it can be demonstrated that the first sale preceded that. So this is a very important concept. Monsanto versus Trantham. The court ruled that the doctrine of exhaustion did not bar Monsanto's claims for patent infringement because the sale of Monsanto's patented gene technology was expressly conditioned on the signing of the restrictive license agreement that prohibits the saving of seed and restricts the use of the seed to a single growing season. So, restrictive licensing agreement. This is another court case that basically says you bought the seed and you signed this. You signed this document, which was basically a written signed acknowledgement entering into a contract. It's a formal bag tag arrangement. Pioneer Hybrid versus Ottawa Plant Food. The court granted summary judgment for the patentee because there was no first unconditional sale, going back to what I just mentioned about sale without restrictions. You never want to sell something that you want to restrict until you have restrictions in place, and you never want to sell it without restrictions to anybody. The court reasoned that in the face of undisputed evidence that the sales were conditional, the patent exhaustion defense is simply inapplicable as a matter of law. Doesn't apply, can't try to use patent exhaustion, and it's failed more times than not. But there are cases where there have been shown companies have made a mistake. They sold some seed in the early stages of development and they had some extra seed. They sold it. Somebody was able to get a hold of the record of that sale and they couldn't get, their patent was basically voided. A US court faced with the Schmeiser facts would likely find the same way. I'm not going to get into the details there, but again, these cases are on both sides of the border that we've talked about a little bit. Anyway, damages could certainly differ between the US and Canada, even though the details in the law are different. Largely, they have the same impact. Largely, the restrictions are pretty much the same in Canada and the United States, even though legally there's some important distinct differences. But where it does differ, it is in damages. So in the US courts are more inclined to award actual damages based on the number of bags of seed saved and replanted. So let's say you saved and replanted, $10,000 worth of seed. All right, so the damages would be $10,000 plus some penalty and punitive damages, whatever that is. And I don't know what the ratios are, but it's not going to be 10,000. There's no incentive. Hey, if we buy the seed, it's 10,000. If we don't buy the seed and we get caught, it's 10,000. If we don't get caught, it's free, right? There has to be a penalty and punitive damage on top of the cost. But that's how it's calculated in the US. How much did they actually steal? And then we'll work out a number from that. Since the Canadian Supreme Court does not focus on Schmeiser's intent or knowledge in determining the appropriate remedy, it is unclear whether a US court would have awarded damages differently in that case. But again, don't worry about the details there. Again, the important things are the concepts of how these protections work. Utility patent, hardest to get, best protection. And then you fit in simultaneously either a PVP for sexually reproduced crops or tubers, or for cuttings and grafting material, you get the plant patent. Together, they make a great team. And you throw on a bag tag or similar type of a sales use contract, powerful tools to protect for those 20, maybe 25 years. So here's the summary. Level of protection and difficulty to obtain go up. Utility patents have the highest level of protection, but also hardest to get. Then you would team that up with a PVP or a plant patent. There is the right to save seed under the PVP, but not when you combine it with the utility patents, and bag tags can close any loopholes or clarify anything. You make 100% sure that in court, there's no effort to minimize liability or damages because the person claims that it wasn't clear. Bag tags make it very clear the things you're most worried about communicating to the purchasers of your seed. That's it for this one.